Well, hello, everyone, and welcome to One Civil Law. And for today's story, we turn our attention to the issue of Eric Adams, the New York City mayor. Eric Adams was indicted by the Biden administration relating to some potential malfeasance, and Trump asked the case to be dismissed without prejudice. That would mean that the government would be able to bring those charges back at another time. But the court, in hearing the case, has decided to dismiss it with prejudice, meaning the case goes by forever unless it is overturned by the Court of Appeals, which seems unlikely. So in order to discuss this, we're going to discuss the legal rationale. So we turn our attention to the case of United States of America versus Eric Adams in this opinion order from the United States District Judge. On February the 14th of 2025, the Department of Justice filed a motion seeking to dismiss without prejudice, meaning it could be retried, the indictment against New York City Mayor Eric Adams pursuant to law. The DOJ motion states the dismissal of the case is justified for several reasons, including because continuing these proceedings would interfere with the mayor's ability to govern, thereby threatening federal immigration initiatives and policies. A critical feature of the DOJ's motion is that it seeks dismissal without prejudice. That is, the DOJ seeks to abandon its prosecution of the mayor at this time while reserving the right to reinitiate the case in the future as long as it would be within the statute of limitations. DOJ does not seek to end the case once and for all. Rather, its request, if granted, would leave Mayor Adams under the specter of reindictment at essentially any time, as long as the statute of limitations had not expired, and for any reason. The court declines its limited discretion under 48A to endorse that outcome. All right, so this is actually a really interesting aspect of the relevant law. So the court typically, its motion here, its power here is very sort of minimal in sort of this. It normally has to grant this as a matter of course when the government wants to dismiss. So if the government seeks to dismiss, normally the court has to dismiss it. But it can refuse, essentially, if the court finds that the government's motion is abusive or basically beyond the pale in some sense, right? So this idea of like, well, we're just going to drop the charges to bring them back. We're just going to drop the charges to bring them back. Basically, we're toying with you. It's like, this isn't really good faith. We're just kind of toying with you. Or we bring the charge would be another example. Like we bring the charge and we run it for a while, but we don't actually swear in the jury, so there's no double jeopardy until you swear in the jury. So we run the case for a while, and then we dismiss, and then we bring it back. And we just kind of run the case without it ever sort of getting to a stage where it would be dismissed. So basically, there's an escape valve here by the court where they can be like, no, I'm not going to do what the government wants because it's jerking the defendant around. And, you have to show a lot to make that happen. But that's basically what happened here. The court said that the government is jerking the defendant around, and so not so much. Instead, therefore, it dismisses the case with prejudice, meaning the government may not bring the charges in the indictment against Mayor Adams in the future. In light of the DOJ rationales, dismissing the case without prejudice would create an avoidable perception. The mayor's freedom depends on his ability to carry out immigration enforcement priorities of the administration, and he might be beholden to demands of the federal government than the wishes of his own constituents, which also raises concerns relating to blackmail and extortion, incidentally, because we might be forcing someone to do something they don't want to do in exchange for not prosecuting them. And so that's a problem, potentially, because extortion, right? Yeah. Notably, Mayor Adams has filed his own motion seeking to dismiss with prejudice on other grounds, and the DOJ has not opposed the motion, effectively waiving any opposition to permit dismissal. The parties offer the court no basis to dismiss this matter in a case that would allow DOJ to reinitiate in the future, and the court declines to do so. Various groups have submitted friends of the court briefs urging this court to go further and deny the motion to dismiss altogether, arguing the reasons DOJ has given to justify dismissing this case are unsubstantiated or contrary to the public interest. Because, after all, maybe he did a bad thing. If you believe he did a bad thing, if you believe he broke the law, right, then dismissing it without prejudice would mean the case goes away forever. And so that's, somewhat disfavored as a result. We don't normally do that. But, sometimes The court ultimately declines their invitation to deny the motion, but it concludes many of the arguments of the amici have merits. DOJ's first asserted rationale for dismissing the case, that it's been tainted by appearance of impropriety, is unsupported by any objective evidence. So their government's rationale doesn't make any sense, which is a pretty strong indication that they're doing something for other than the reason that they're trying to state. Okay. The rule is unsupported by any objective evidence. Rather, the record before us indicates the U.S. Attorney's Office for the Southern District of New York prosecutors who worked on the case followed all appropriate department guidelines. There is no evidence, zero, they had improper motives in sort of bringing the charge in the first place. So that might be a ground to be concerned about things, that it's uneven prosecution, selective prosecution, retaliatory in some sense. But there's no evidence of any of that stuff. Instead, DOJ's memorandum directing dismissal of the case took care to note it did not call into question the integrity and efforts of the line prosecutors or efforts of the U.S. Attorney leading the office at the time of the memorandum. So even the DOJ is like, yeah, we didn't do anything wrong. So we're not doing it because we did something wrong, So it's like, okay. And DOJ's assertion that this case, which was brought 9 months before the 2025 New York mayor primary, somehow amounts to election interference, lacks any support in Justice Department guidelines or past practice. Yeah, no. I mean, that seems a bit odd. In fact, timing of this case is entirely consistent with prior public corruption prosecutions. We've kind of seen some of this stuff before. All this suggests that the appearance of impropriety rationale is not just thin, but pretextual. So it's like the court is not buying any of these reasons as real reasons. As for the immigration enforcement rationale, to the extent the DOJ suggests that Mayor Adams is unable to assist with immigration enforcement while this case is ongoing, such an assertion is similarly unsubstantiated. Indeed, shortly after the DOJ made a decision to seek dismissal, and while the indictment was still pending, the mayor announced he would permit immigration to operate at Rikers Island Jail Complex, an act that appears to be contrary to New York City law. In other words, the record does not show the case has impaired the ability of immigration because the case was still pending and he was able to do it. So he was doing things. So he doesn't seem to like he's impaired. Instead, it shows after DOJ decided to seek dismissal, the mayor took at least one new immigration-related action consistent with preferences of the new administration. Everything here smacks of a bargain. Dismissal. Everything here smacks of a bargain. Where did I lose my place? Everything here smacks of a bargain. Dismissal of the indictment in exchange for immigration policy concessions, which raises concerns on federalism grounds because you have the federal government trying to force the state to do something, so that could be viewed as commandeering potentially. If they were doing it purely voluntarily, then, not so problem. If they're doing it in exchange for the money, which is normally how that thing works. Normally when the government wants something, they're like, will you do it? And they're like, no. Oh, how about money? And people go, yay, money. But that's okay because the government, this government of the state is accepting money from the federal government to do what it wants. But here, this is a little bit different, right? This isn't a bargain for exchange. The money is a bargain for exchange. It's a contract, if you like. You enforce our policies, we pay you. Sounds kind of like a contract. This is a little bit different. Do what we want or we prosecute you. Yeah, that's much less voluntary. Or at least it's possible to view it that way. Taking a step back from the particulars of this particular case, DOJ's immigration enforcement rationale is both unprecedented and breathtaking. DOJ cites no examples, and the court is unable to find any, of a government dismissing charges against an elected official because doing so would enable the official to facilitate federal goals. So we've never done anything like this before. We've never done this. This is apparently a first. And anytime it's a first, it's going to get the court's attention. Because it's like you seem to be doing something radically different than anyone's ever done before. Not sure necessarily about your reasons, motives, or support of law. So yeah. And DOJ's assertion that it has a virtually unreviewable license to dismiss charges on this basis is disturbing its breath, implying that public officials may receive special dispensation if they're compliant with incumbent administration policy priorities, which sounds, again, problematic from an extortion frame. That suggestion is fundamentally incompatible with the basic promises of equal justice. Ultimately, however, there are two reasons why these points do not support outright denial of the DOJ's motion to dismiss. The first is the court's principal role in deciding a motion of this nature to protect rights of the defendant, and denying dismissal of the case would not do that here. In fact, to the extent the government may be seeking to extract policy concessions from the mayor, dismissal with prejudice rather than continuation of prosecution best address the concern. It ensures that going forward, changes to the indictment cannot be used as leverage. So not so much with your potentially illicit leverage. And by the way, this makes broad sense, right? If this was even happening in other contexts, this would be a problem, right? Because extortion or blackmail can even be for legal things. If I'm using that as pressure to get you to do something that you wouldn't normally do, right? So if I'm doing something, even if it's legal for me to do that thing, but I'm doing it with in mind to potentially force you to do something against your will, you're talking about extortion. I'll give you a good classic example, at least. Let's suppose that you've committed a crime against me. Okay, can I report you to the police? You bet your ass, right? No problem. What if I come to you and say, give me $10,000 or I'm going to report you to the police? That would be extortion, right? It's legal for me to report you to the police, but now I'm trying to extract money from you by using this threat. That's a problem. And so this is sort of comparable to this situation. If I'm breaking the law, can the government prosecute me for it? Sure, but can they hold it over my head to get me to do something that would be legal for me to do, but they're forcing me to do it by holding it over my head? No, not necessarily. That's a problem. So yeah, the line between plea bargain and extortion can get tricky sometimes, but this looks more like the extortion end of the equation on first blush, or at least it's concerning enough in that domain to potentially counsel us to try to take some sort of alternative path here. The second and most important fundamental reason is the court, if it were so inclined, would have no way to compel the government to prosecute a case like this. So if I thought that, this guy, there's sufficient evidence to bring this case, and that would be the better remedy, I can't force the executive to do that. I can't force them to prosecute. So maybe this guy violated the law. Maybe he should be prosecuted for it, but I can't force you to prosecute. But I can prevent you from threatening the force, for an illegitimate reason. If an individual prosecutor seeks to dismiss a case for improper reasons, a court can deny the matter and send it back to the government, which can reassign the case to another prosecutor. So if the problem is an individual prosecutor, then I can just kick that prosecutor off the case and give it to someone else who won't do the blackmail. But of course, this is coming from a little bit higher up on the food chain than just the individual prosecutor. This came from the White House, who was trying to do this. So that is a bigger problem. But whereas here the court has substantive concerns about the reasons for dismissal offered by the Justice Department itself, again, not the line prosecutor, but the DOJ proper, bigger problem. The court does not have the same option. Yeah, I have no way to get this out of the DOJ. If it were just some prosecutor, I can kick the prosecutor off the case and find me a different prosecutor. But this is the entire DOJ. What am I supposed to do? I can't kick the entire DOJ out. There's no one left. A court cannot force the Department of Justice to prosecute a defendant. That is by design. In our constitutional system of separation of powers, a court role in a criminal case is to preside over the matter, not to decide where a defendant should be prosecuted. Normally, prosecution, of course, the decision to prosecute is within the province of the executive, right? It is discretionary. But, again, this sort of relates to something I said the other day. They can do it for good reasons. They might be able to do it for bad reasons, but they can't do it for bad reasons. When the government starts doing things for bad reasons, that's a problem. So, yeah. The court is not aware of any authority it has to appoint an independent prosecutor outside a limited context of criminal contempt. Consistent with that understanding in light of the particular facts, the court finds no way to deny the DOJ's motion. Finally, it's important to clarify the court's decision today is not about whether the mayor is innocent or guilty. Mayor Adams, like any person accused of crime, is presumed innocent. If this case were to proceed to trial, it would be the government's burden to prove beyond a reasonable doubt each element of the offense. Because of DOJ's decision to abandon this case, the trial will not occur. But unlike many motions under Rule 48A, the government's motion to dismiss this case is expressly not based on strength of the case. So that might be like a reason for the state to want to dismiss. It's like, oh no, our case is weak. We'd like to try to dismiss and maybe get some more evidence, if you don't mind, without proceeding forward. It's like, okay, that makes more sense. But the DOJ isn't saying our case is weak. They're saying they have other reasons. That's a problem. Neither dismissal of this indictment nor the length of this opinion should be understood as any kind of statement about the merits of the allegation against the mayor. The decision is also not about, and the court expressed no opinion on, where the case against the mayor should continue, based on the kind of factors a prosecutor might consider in a typical case, including strength of the case, prosecutor's general deterrence value, the government's enforcement priorities, and case relationship to the government's overall plan. Courts are particularly ill-suited to weigh out such factors, and this court declines in that thicket. In our constitutional system, the decision is best left to the political branch of our government, which is ultimately accountable for its actions. Part of this court's limited role under 48A is to shine a light on the reasons DOJ has decided to dismiss this case, leaving the most important judgments to the public. Accordingly, and for reasons set forth below, the government's motion is denied and granted in part and denied in part, and the case is dismissed with prejudice, meaning it goes away forever. So all those things. All right. So we'll discuss a little bit about the facts of the case. The investigation of then Brooklyn Borough President Eric Adams began in the summer of 2021. It concerned travel benefits and campaign contributions he allegedly received from Turkish nationals. That's a problem. Didn't register as a foreign person, I assume. Approximately 3 years later, on September 2024, a grand jury returned a 5-count indictment with 1 count of conspiracy of wire fraud and to receive campaign contributions from foreign nationals, 1 count of wire fraud, 2 counts of solicitations of contribution by a foreign national, and 1 count of bribery. That doesn't sound good. DOJ officials were aware of the investigation and timing of the indictment. Consistent with DOJ policies, attorneys at the U.S. Attorney's Office for the Southern District informed DOJ leadership that if the grand jury voted to indict, they intended to, among other things, unseal the indictment and hold a press conference. On October the 2nd of 2022, Mayor Adams appeared before the court. During the conference, the government stated it was likely it would follow a superseding indictment, later clarifying it was possible additional charges would be added, such as, for example, failing to register as a foreign agent. The court acknowledged that the public and Mayor Adams has an interest in a speedy trial, which is heightened in the context of the election calendar. The court also noted this is obviously of significant public interest and consequently directed the parties to, where possible, file documents on the public docket. At a subsequent conference, the court again noted the public and Mayor Adams' interest in the case, particularly given the then existing election cycle. The court ultimately set the trial for April 2025, explaining it took into account a variety of factors, including likely the need for proceedings with respect to classified information, the time it would take for the mayor's counsel to review significant volumes of discovery, the trial schedules of other cases involving public officials tried in this district, and competing proposals. All right, so I'm going to skip some of the initial proceedings because they don't really matter for our second. So we're just going to go through a brief history of the entire case, but we'll skip that. All right, with respect to the government's motion to dismiss, on January 31st of 2025, members of Mayor Adams' legal team, including Alex Spiro, staff at DOJ, including then Acting Attorney General Emily Bolf, and her staff from the U.S. Attorney's Office, including then U.S. Attorney Danielle Sassoon, met together. According to a letter filed on the docket, the meeting was at the acting DAJ, the Deputy Attorney General's invitation to discuss how the case might be affecting Mayor Adams' ability to do his job and whether there was evidence of politicization. Defense counsel's letter to the court states that at the end of the meeting, acting DAG Brove asked the lawyers and SDNY lawyers to memorialize their respective positions in writing. The follow-up letter from Mayor Adams' counsel to acting DAG Bove, titled February 3rd, 2025, was also filed on the docket. The letter stated that the criminal case against Mayor Adams had prevented him from being in lockstep with federal law enforcement, federal agency head, and federal prosecutors with respect to immigration enforcement, particularly the administrative efforts to aggressively enforce immigration laws and remove undocumented immigrants. Layer identified as one of the prominent examples of the indictment's impact the fact that Mayor Adams' security clearance was revoked following the indictment. Well, that's a problem that can be solved instantly by the president. Just a note, right? If the problem is that Mayor Adams' security clearance has been revoked, that problem can be solved instantly by the president because he is the original classifying authority. He has the ability to grant anyone clearance and deny anyone clearance essentially on a whim. So if it's a problem, just snap your fingers, problem solved. Just saying. And of course, this did come from the White House. So if it's like the problem is he doesn't have security clearance. It's like, yeah, but you can fix that instantly. Just do it, and he'll have it again. Anyways, pressing on. The letter also wants to say Mayor Adams' independent abilities to exercise power have been complicated by his indictment, referencing his authority to prevent the Office of Corporation Counsel from litigating challenges to immigration enforcement, prevent appointed city employees from taking public stances against enforcement efforts, reopen the ICE office on Riker Island, and direct the NYPD to supply manpower. Now, why can't he do any of those things? Even though he's under indictment, is unclear. What about the indictment prevents him from doing any of those things? Unclear. Why doesn't he not? Why can't he not do it? I don't know. The U.S. Attorney's Office for the Southern District followed-up letter was not filed on the docket by any party or amici. It does not appear to be publicly available. On February the 10th, the acting Deputy Attorney General Bove sent a memorandum to U.S. Attorney Sassoon, directing her to dismiss this case as soon as practical. Yeah, and the fact that DOJ themselves is directly intervening in a case like this is unusual. Usually the 94 district attorneys, because there is one U.S. attorney for each of the districts. Of course, they have support staff. But in terms of the U.S. attorney, there's 94 of them, one for every district. There are 94 districts. So normally, the U.S. attorney has basically unilateral power to bring charges within their district. So Maine DOJ can intervene. The law allows the attorney general to intervene. But of course, when that happens, it can be a little sus because, like, why are they doing that? That's not normally how that works. There might be reasons, but it does get our attention. It started by noting dismissal will be subject to certain conditions, including that Mayor Adams agreed to writing to dismiss without prejudice. It then explained DOJ reached this conclusion without assessing the strength of the evidence or legal theories on which the case is based, which are issues on which it deferred to the U.S. Attorney's Office. So Maine DOJ is not saying the case was weak. They're not saying they had any problem with the case. That isn't the issue. You also know this directive in no way called into question the integrity and efforts of the line prosecutors. So they're not saying that the line prosecutors were corrupt. It's not because they were corrupt in bringing the charges. It's not because the case is weak. Okay. What's our rationale here for doing this? Unclear. The February 10th decisional memo then stated the Justice Department determined that dismissal is necessary for two independent reasons. Okay. First, it stated the timing of the charges and more recent public actions by the former U.S. attorney had threatened the integrity of proceedings, including by increasing prejudicial pretrial publicity that risked impacting potential witnesses. Yeah, I mean, this is Manhattan. It's the Southern District of New York. You want to say that you've polluted the jury pool in the Southern District of New York? That's interesting, since it's literally the biggest possible jury pool. But okay. The memo also stated that Mayor Adams criticized the prior administration's immigration policies before the charges were filed, and it asserted the former U.S. attorney's public actions created an appearance of impropriety that might implicate concerns raised by the Attorney General's memorandum regarding restoring integrity. I thought you said that you might have didn't have questions, but now you do. As well as an executive order entitled Ending the Weaponization of the Federal Government. It further stated that these actions and underlying cases have also improperly interfered with his campaign in the 2025 election, which at this point is quite a bit of a ways away. So that doesn't quite make sense. Second, the February 10th decisional memo stated the pending prosecutions unduly restricted Mayor Adams' ability to devote full attention and resources to illegal immigration and violent crime that escalated under policies of the prior administration. The memo noted the impact of prosecution on Mayor Adams' ability to support critical, ongoing federal efforts to protect the American people from disastrous effects of unlawful mass migration and resettlement, as described in the executive order. It also drew a comparison between DOJ's decision to dismiss and prior administration's decision to release violent criminals in pursuit of foreign policy goals. How that has anything to do with the mayor is beyond me, right? If the prior administration was, not enforcing immigration, what does that have to do with the mayor? The authority to enforce immigration is the federal government's authority. They're the one with the power. The state government has no power in the first instance to change anything with respect to immigration. Nathan, lawyer for $5, says this was the only ethical thing the judge could do. Can't force prosecution, but can stop it. Yeah, I mean, it certainly seems that way, right? None of the DOJ's rationales really seem like good reasons. They seem like corrupt or quasi-corrupt reasons. They seem questionable at best. Thank you for the $5. In a footnote, the memo referred to a follow-up letter submitted by the U.S. attorney after the January 31st meeting, purporting to quote it as acknowledging the government is not offering to exchange dismissal of the criminal case for the assistance on immigration. Aren't you, though? Aren't you? Kind of seems like that might be what's up. As noted above, this letter has not been filed and is not otherwise publicly available, so we don't even know what the letter says. The February 10th decisional memo also stated that the case would be reviewed by the confirmed U.S. attorney in the Southern District following the election. Yeah, that seems odd. Subsequent letters. The February 10th decisional memo triggered a remarkable exchange of letters between the U.S. attorney and the DOJ, following a sequence of unusual events at DOJ that reported in news articles and have been submitted as exhibits by various amici, including one filed by former federal judges. On February the 12th of 2025, the U.S. attorney Sassoon sent a 9-page letter to the Attorney General stating that acting DAG's Bove's memo raised serious concerns that render the contemplated dismissal inconsistent with the ability to prosecute and federal crimes without fear or favor and to advance good faith arguments before the court. The U.S. attorney further stated, I cannot fulfill my obligations, effectively lead my office in carrying out department policies, or credibly represent the government before the courts if I seek dismissal from this case. The letter then proceeded to address, thank you, Alan Parker, for the 20 gift memberships. As always, we do appreciate your extended support. You're very generous. The Sassoon letter then proceeded to address rationales for dismissal set forth in the memo. First, with respect to recent conduct by the former U.S. attorney, the letter explained the investigation began before Mr. Williams took office. It was when he was still borough president. He did not manage the day-to-day investigations, and charges in the case were recommended or approved by 4 experienced career prosecutors, the chief of the SDNY Public Corruption Unit, and career prosecution at the Public Integrity Section of Justice. So not surprisingly, because of its political sensitivity, the U.S. attorney sought approval to bring this case from the DOJ in the first instance. So yeah, they consulted a whole bunch of people. It's like because of its sensitivity. So you got approval from a whole bunch of people in the first instance. Mr. Williams' decision to ratify the recommendation does not taint the charging decision. And notably, Adams has not brought a vindictive or selective prosecution, nor would one be successful. Yeah. Without attempting to defend Mr. Williams' motive or conduct, this assumed letter conclude the appropriate chronology of the investigation and strength of the case show that Williams' conduct since leaving the government cannot justify dismissal. Next, regarding the timing of the indictment in relation to the 2025 New York mayoral election, the Sassoon letter stated that the decision to charge Adams in September 2024, 9 months before June 2025 primary, and more than a year before the November 2025 election, complied in every respect with long-standing Justice Department policies regarding election year sensitivities and the applicable Justice Manual provisions. So we are sensitive about prosecutions relating to elections, but we can bring them if they are sufficiently detached in time from the election, because otherwise we might never be able to bring prosecutions. That might be dumb. You get voted into office and we can never prosecute you. That might be a problem. The letter noted that the timing of charges in this case is consistent with charging timelines of other cases involving other officials, both in the district and elsewhere. It further stated that I'm not aware of any instance which the department has concluded the indictment brought this far in advance of an election is improper, because it may be pending during an election cycle, let alone that a validly returned and facially supported indictment should be dismissed on this basis. Again, nothing like this has ever happened before. And anytime it's the first time, it's going to definitely get someone's attention because you're trying to deviate in a new way. The letter further stated that the Department Justice Manual requires that when investigative steps and charges involving public officials could be seen as affecting the election, the prosecuting office must consult with the public integrity section, and if directed to do so, the DAG. So again, the DOJ has said that if there's a problem, you need to look at this and get approval from Main Justice. Nate the lawyer gives $5. Incidentally, by the way, this isn't the only situation in which approval from Main Justice is either required or strongly encouraged. Other examples that might get the approval from Main Justice might include the investigation of an attorney or the investigation of a newspaper. Because if we're going to go into the lawyer's office or the newspaper's office and start seizing records, that obviously has implications with respect to constitutional guarantees, freedom of speech or right to counsel. So, if we're going to do that, we need to get approval to make sure that, we're not doing this willy-nilly, and also to make sure that we're doing it in a way that doesn't prejudice the rights of innocent third parties or potentially innocent third parties. So, and also doesn't, hurt the Constitution with respect to freedom of speech and freedom of press. So those are some other examples in which Main Justice approval might be required. Basically, if it's particularly sensitive, is the underlying theme. It also expressed concern that dismissing the case would amplify rather than abate concerns about weaponization of the department, and noted that the U.S. Attorney's Office for the Southern District was prepared to seek a superseding indictment from a new grand jury that would add an obstruction conspiracy count based on evidence Adams destroyed and instructed others to destroy evidence and provide false information to the FBI, and that would add further factual allegations regarding his participation in fraudulent straw donors. So it's not only do I not think the case is weak, I'm ready to go get some other charges relating to this. I'm ready to press this forward. So yeah. The Sassoon letter first stated that Mayor Adams' advocacy to DOJ regarding immigration enforcement should be called out for what it is, an improper offer of immigration enforcement assistance in exchange for dismissal. Again, right? You might be able to do it for good reasons. You might be able to do it for no reasons. But if you're doing it for corrupt reasons, that is a problem, right? And also it's a problem because it conflates the mayor in his personal capacity with the mayor in his public capacity, right? When the mayor was being charged criminally. He wasn't being charged as the mayor. That he wasn't the mayor for the purposes of the indictment. He's just a guy. He's just a guy who happens to hold a job called mayor, but that had nothing to do with the indictment. It had to do with campaign finance violations and, accepting bribes and so forth and so on, in which he's just the guy, right? We're prosecuting the guy, not the office, okay? And one of the problems is, among other problems, is that this exchange, in addition to being kind of quasi-extortionist, also conflates the guy with the office, because you're asking him to, as part of this exchange or this understanding or this whatever, you're asking him to up immigration enforcement. Well, that isn't something that the guy can do anything about. The guy has no power to direct New York City to do anything. He's just a guy, right? He has no power in his personal capacity to direct New York City to do jack shit. He only has power in his professional capacity to direct the government to do jack shit. But he's being charged in his personal capacity. So you're conflating his personal and professional capacities. Plus, also, you have another concern relating to the issue relating to commandeering, because you have the federal government now trying to force the state government to do something it doesn't want to do, which raises commandeering considerations. So you have all kinds of problems relating to this. Many, many question marks. And it's a bit of an issue. The letter asserted that in the January 31st meeting, Adams' attorneys repeatedly urged what amounts to a quid pro quo, indicating Adams would be in a position to assist the department, incidentally, in its professional capacity, only if the indictment were dismissed, which relates to his personal capacity. That's a problem. It further stated it would be a breathtaking and dangerous precedent to reward Adams' opportunistic and shifting commitments on immigration and other policy matters with dismissal of a criminal indictment. Could be a problem. The Sassoon letter also noted that a member of the team who took notes during the meeting was admonished by the acting deputy attorney general, who then directed the collection of those notes at the meeting's conclusion. Yeah, they're trying to take up the notes that were taken during the meeting. We don't want a written record of the meeting. That seems problematic. Is it possible we don't want a written record because maybe we're not doing everything on the up and up? Are we concerned about the paper trail? The letter also noted that Sassoon was baffled by the rushed and superficial process by which the decision was reached in seeming collaboration with Adams' counsel and without the U.S. attorney's input on the ultimately stated rationales for dismissal. Again, kind of weird for DOJ to hijack the U.S. attorney's case. That isn't normally what happens. It ended with a statement that Sassoon was preparing to offer her resignation should the attorney general be unwilling to meet or reconsider the directive. It's like, I can't do this. I can't. It raises problems. And of course, as we've mentioned before, of course, within the context of the Karen Reed case, the government has special ethical duties just for them. They have special ethical duties just for the prosecutor. And the U.S. attorney, the guy in charge of the office in the Southern District, is like, I think this raises too many problems and raises ethical concerns. I'm not sure I can do this anymore. So I think I'm going to have to quit. It's nice for a prosecutor to actually respect their ethics. I appreciate that. Probably could use more of that, to be honest, in some situations. On February 13th of 2025, the acting deputy sent an 8-page letter response to Sassoon. First, the acting deputy attorney general accepted Sassoon's resignation and stated, "You lost sight of your oath that you took when you started the Department of Justice by suggesting you retain discretion to interpret the Constitution in a manner inconsistent with the policies of the democratically elected president and Senate-confirmed attorney general." Well, I mean, not for nothing, but there is quite a lot of case law out there on the issue. So, I mean, if you're asking me to do something, and of course an attorney is bound by ethics, and it's like, I don't think I can do this. And they're like, well, like the attorney general's in charge. I'm like, yeah, I guess the attorney general's in charge, but I can't make it work. So, I'm out. He then stated DOJ will be placing 2 assistant U.S. attorneys principally responsible for Adams' case on off-duty administrative leave, and the prosecution will be transferred to Main Justice, which would follow the motion to dismiss pursuant to Rule 48. He then reiterated DOJ's motion for the decision to dismiss and added additional points not raised during in the memo. For instance, he alluded to many other concerns about the Adams case, knowing the case turns on factual legal theories that are at best extremely aggressive. I'm not sure about any of that, to be honest, but okay. The letter also raised concern about questionable behavior reflected in certain of the prosecution team decisions, including how certain witnesses have been treated. Okay. Yeah, all right. I mean, if you feel like the case is that thin, though, just dismiss it outright. Right? I mean, if the Deputy Attorney General really believes that this is stretching the law and stretching the facts to the breaking point, if they really believe that, just dismiss it outright. That would be, but why are you keeping it open? Is something going to change radically in the future? I don't know, ma'am. I don't know. Things are a little sus. On or around February the 14th of 2025, the Southern District Assistant U.S. Attorney, a member of the prosecution team, sent an email tendering his resignation. In the email, the Assistant U.S. Attorney stated that DOJ's first justification for seeking dismissal regarding purported appearance of impropriety was so weak as to be transparently pretextual. Yeah. He then described the second justification regarding immigration enforcement and national security as being worse because no system of or liberty can allow the government to use the carrot of dismissing charge or the stick of threatening to bring them again to induce an elected official to support its policy objectives. Yeah, again, improper reasons. This is suspiciously blackmail, extortion adjacent. This seems questionable. Plus commandeering doctrine. Plus other problems. Yeah. Later that day, the government filed a motion requesting the court notice the withdrawal of the assistant U.S. attorney as well as other assistant U.S. attorneys as counsel. News articles attached to amici briefly submit by former judges report various events relating to this around the same time. On February the 13th, 3 days after the date of DOJ's decision memo instructing the U.S. attorney to dismiss the case without prejudice, Mayor Adams announced he'd be implementing an executive order that would allow federal immigration officials to operate at Rikers Island. Yeah, that looks kind of suspiciously quid pro quo, this for that. Yeah, 3 days later, he's like, oh, I've had a sudden change of heart. I'd very much like ICE to be at Rikers now. That sounds like fun to me. Yeah, three days after the dismissal. I wonder if maybe it was an exchange for benefits that conflates your personal and professional roles. A decision in apparent tension with the 2014 New York City law that removed ICE from jail complex, which incidentally, by the way, as we've stated before, should be legal because this deals with separate sovereigns and all that, right? So they can't interfere, but they don't have to help. So the law, this is all the basis of sanctuary cities, by the way. Is the exact same basis. And also, incidentally, the sanctuary cities for Second Amendment, which some other cities have done in the same idea. So like the federal government has the ability to enforce federal law. You're not required to help, but you can't interfere. So are you required to give DOJ or ICE, an office in the city jail? No. Right? The city jail belongs to the city. You're not required to give them an office. If they want to come, with a warrant and, come into your jail with a warrant to, find some people and arrest them or something, maybe. But the office is assistance, and you can get that from the government. They can agree to it, usually in exchange for money. Yay, money! But you can't make them. The state can't force the federal government, and the federal government can't force the state government. They each can enforce their own law. Neither can interfere with the other, and so forth and so on. That is correct. That day, Mayor Adams met with the administrator's border czar. The following day, the two made a joint television appearance, during which the latter stated, "I came to New York City and I wasn't going to leave with nothing," adding, "If Adams doesn't come through, I'll be back in New York City. I'll be his office up his butt saying, 'Where the hell is the agreement we came to?'" Oh, that sounds like an agreement. Oh, okay. Yeah. Who is making the agreement? Who's making the agreement? Eric Adams, the guy, or the office of the mayor? Who's making the agreement? The mayor later released a statement after his television appearance stating, "I want to be crystal clear with New Yorkers. I never offered, nor did I offer anyone on my behalf, any trade of my authority as your mayor as an end of my case. Never." Yeah, okay. Well, we'll see how that goes. We'll see if perhaps quietly they're less cooperative with ICE in the relatively near future. 2 weeks on a Friday, quietly, at the end of the day, we're going to be like, yeah, maybe ICE can't be in our jails anymore. Yeah, we'll see how it goes. Meanwhile, at DOJ on February the 13th, 5 attorneys, including the Deputy Assistant Attorney General, who oversaw the Public Integrity Section, acting head of Public Integrity, and 3 other Public Integrity sections resigned. The next day, the acting Attorney General told the remaining DOJ career Public Integrity prosecutors they had an hour to decide amongst themselves who would file the motion. Ultimately, someone agreed. Yeah, this is looking a little sus. This is looking a little sus. Now, I don't want to be misunderstood here, right? To the extent that we are doing things that are lawful, Maine DOJ can interfere. So if you had a prosecutor who was refusing to prosecute, for example, because they don't want to prosecute that particular crime, right? The administration has the ability ultimately to decide within their prosecutorial discretion what their discretion is. So if you had some guy, if you had like one of the 94, U.S. attorneys who said, "You know what? I don't want to prosecute any illegal immigrants. I like illegal immigrants. Illegal immigrants are my favorite things, and I don't care if illegal immigrants violate the law. I don't want to prosecute them because I have the feels, right? I have the feels, right? It's like, oh, okay, but Maine DOJ can be like, no, we don't like those reasons. We really want you to prosecute them." And he's like, "But I don't wanna." So, can they fire the guy? Yeah, probably. They can also just yank it out of him. That's another thing they can do. They can just be like, okay, Maine DOJ is going to take it over, or we're going to give it to a different attorney general, a different person, or whatever. So, yes, the attorney general has the ability to command, ultimately, the Department of Justice. They are the attorney general. But, again, they can do it for good reasons. They might be able to do it for no reason, but they can't do it for bad reasons. If they do it for bad reasons, they have the problem. They can't do it corruptly. So, yeah. The government's Rule 48 motion to dismiss. On the evening of February the 14th of 2025, the government filed a motion seeking to dismiss without prejudice with leave of the court pursuant to the rule. The motion was signed by the Deputy Attorney General and Edward Sullivan, who replaced the AUSA as the counsel of record. Okay. The motion indicates through counsel Mayor Adams' consent in writing to the motion. The motion further states the acting Attorney General, Deputy Attorney General, determined dismissal is necessary and appropriate based on unique facts and circumstances of this case. Yeah, I don't know, ma'am. I don't know. And we've seen, incidentally, with the DOJ, when them being corrupt and this going the other way, right? What was the name of Flynn, right? General Flynn, when he was being prosecuted by the Biden administration and they were fucking around and finding out, right? And then the judge at one point's like, fuck you. You can't, DOJ just jerk General Flynn around. That was the right answer. So, when the Biden administration was trying to jerk Flynn around, at one point, the court's like, fuck you. We're not doing this anymore. The case goes away. So it's rare, but it can happen. And it appears that, it happened again here. So we've seen it under different administrations. We've seen it with Republican presidents, Democrat presidents. Republican people are being prosecuted. Democrat people are being prosecuted. The rule of law, of course, guides us all. It's a beautiful thing. Let's see what happened next. First, the motion stated dismissal is necessary because of appearance of impropriety and risk of interference, which implicated an executive order, which again, even the president, right? He can do things for good reasons. He can do things for no reasons, but he can't necessarily do things for bad reasons. There are corrupt reasons. Or I don't know if necessarily corrupt is necessarily the right word. Maybe corrupt is too strong a word. There are illegitimate reasons or illegal reasons. How about that? That's less charged. So you can't do certain things. You might be the chief executive. You have the ability to execute the law, but of course you have to execute the law, and some of the things you're doing may not be legal. So that's one of the things that courts are for. And it's a good thing, because if that wasn't one of the things courts were for, then General Flynn would still be prosecuted and probably in jail, because the courts would have no role, and that would be kind of dumb. All right, where were we? Acting DAJ Burove reached the conclusion the motion explained based on other things, a review of a website maintained by the former U.S. Attorney Damon Williams in an op-ed. Second, the motion stated the acting Deputy Attorney General concluded that by continuing these proceedings would interfere with the defendant's ability to govern, which possesses unacceptable threats to public safety, national security, and related federal immigration initiatives. Incidentally, why would it do those things? Because he'd be distracted? I mean, the mayor does have staff and stuff that could facilitate his wishes. So why would it interfere with him? Unclear. It might interfere with the guy, but does it interfere with the office? And if so, why? Acting Deputy Attorney General Burove reached the conclusion after learning, among other things, that as a result of these proceedings, Adams has been denied the sensitive information that Burove believes is necessary for Adams to help govern the city. Once again, this is a very easy to solve problem. That's how you solve that problem. Instantly. So, yeah. In conclusion, the motion requests that this court entered an order of nolle pros pursuant to rule without prejudice with respect to all the charges of the indictment. On the next business day, February 18th of 2025, this court issued an order instructing the parties to appear for a conference on February the 19th. The court informed the parties that they should be prepared to address, among other things, the reasons for the government motion, the scope and effect of the consent in writing, and the procedure for resolution. The court further instructed Mayor Adams to file his consent in writing on the docket. Mayor Adams complied with the court's request and filed his written consent, a 2-sentence letter signed by counsel. At around the same time on February 18th, most of the mayor's counsel filed a letter describing above, responding to several motions for leave to file amici. In the letter, Mayor Adams' counsel denied having engaged in a quid pro quo concerning immigration, stating, "We've never said or suggested to anyone that Mayor Adams would do X in exchange for Y, and no one said or suggested to us they'd do Y in exchange for X." The letter concluded by offering sworn declarations to confirm these points. No one may have actually said it out loud, but that doesn't necessarily mean there wasn't an understanding. The mafia, for example, knows how to say things without saying things. So, no one might have actually said, you do this for me and I do this for you. But, subtext and so forth and so on. The letter concluded by offering sworn declarations to confirm these points. The court held a conference on February 19th, 2025. Acting Deputy Attorney General Burove appeared for the government. Mr. Spiro and Mr. Burke appeared for Adams. During the conference, Mayor Adams swore under oath that nothing had been left out of the written 2-sentence consent. Mr. Spiro that he had not entered into any other agreements, written or otherwise, with the government, that nothing else had been promised to induce his consent. Promised, I think, the word promised, I think, is doing a lot of heavy lifting in that sentence. Nothing had been promised, but, a wink is as good as a nod to the blind man, as they say. And no one had threatened him in any way to consent it. Again, explicitly, sure. Implicitly, Mr. Spear also reiterated his offer to swear under oath as to the absence of X in exchange for Y. With respect to rationale for the Rule 48 motion, DOJ confirmed the motion contains no statement about the strength of the case in terms of fact or legal theory, and there are two bases which are laid out in paragraph 5 or 6. While the acting Deputy Attorney General added he does have other concerns, he expressly disclaimed reliance on them. Well, if you disclaim reliance on them, then the court's only going to consider what you say, right? I mean, duh. The court's only going to consider what's in the file. I have other reasons. Really? What are they? I don't want to tell you. Oh, okay. Well, unsurprisingly enough, I'm not going to consider those other reasons. Oh, but I have other reasons. They're good ones. I promise. Yeah, no, that's definitely not how that works. As to whether there were any sort of agreement between DOJ and Mayor Adams with respect to immigration, the acting Deputy Attorney General both said, "You have a record, undisputed, there's no quid pro quo," but added, "I don't think it's correct. Even if there were a quid pro quo, there'd be any issue." Yeah, no, I'm not so sure about that, because once again, you're leveraging the man to get to the office. There's issues of commandeering doctrine because you have the federal government trying to put pressure on the state government. It's also potentially not a legitimate thing. So you're heading rapidly into extortion adjacent territory. There are problems. The court noted the parties' alignment on Rule 48A motion. In such situations, it's sometimes helpful to have adversarial testing to assist the court. Acting DAJ Bove acknowledged the court has broad discretion about how, if whether, to invite amici, but objected to a motion for leave to file an amici by former U.S. attorneys based on their counsel. Mayor for Adams registered the same objection. Neither party objected to an amicus motion filed by common cause. It is a little unusual. I mean, it's like, why do you have an objection to amici? It's also pretty unusual to have amici in a district court proceeding, to be quite fair. But of course, this is a high-level proceeding. So it's like, why do you have an objection to amici? Well, we like some of the amici, but not other amici. Like, why? I don't know. After the conference on February 21st, 2025, the court issued an order that directed next steps for resolution. In light of the government's motion and representation, the court adjourned sine die, which means no particular date to be scheduled, the trial, and all other deadlines set forth in its order. So I'm adjourning with no set date to resume at this time. That's what sine die means. To assist with this decision-making via adversarial process, the court also exercised inherent authority to appoint Paul Clement, who is the GOAT. Paul Clement is the absolute GOAT, and although Elizabeth Prelogar has claim to the throne. But yeah, it's like, oh, I want help from a third party. It's like, I want someone else to argue this case. Okay, cool. Who are you going to get? How about Paul Clement? Oh, yeah, that's pretty good. Yeah, let's get Paul Clement. I love Paul Clement. He's so good. He's the best. So exercise inherent authority to appoint Paul Clement as an amici to present arguments on the government motion to dismiss. Again, not unheard of, but unusual, right? Can you have amici make arguments at a case in addition to filing? Yes, it's happened. It even occasionally happens at the Supreme Court, although almost all the time when it's an amici, it's the U.S. attorney who's the amici, right? So that happens a lot, right? We have a lawsuit between two parties. The DOJ isn't one of the parties, and suddenly we have the U.S. attorney there as an exciting third party, right? That which makes them an amici. So the U.S. attorney participates quite frequently as an amici. But every once in a while, albeit very rarely, even the Supreme Court will allow a third party who's not the U.S. attorney to argue orally. It's unusual, but it has been known to happen. And does it happen at the Court of Appeals or district court? Again, very, very unusual, but not unheard of. So I was like, I'd like someone else to argue a different side of this position. So how about Paul Clement? He sounds good. Fun. Specifically, the court ordered amici and the parties to address the legal standard for leave to dismiss, whether and to what extent the court may consider materials other than the motion itself, under what circumstances, if any, additional procedural steps or further inquiry would be appropriate before resolving the motion, under what circumstances, if leave is granted, dismissal should be with or without prejudice, if leave were denied under Rule 48, what practical consequences might follow, and any other issues the party or amici considers relevant. Given concern raised by the parties regarding Mayor's responsibility and the burden of continued appearance, the court informed Mayor Adams that while he has a right to appear at any future proceeding, he need not do so given the current procedural posture of the case. Later that day, Mayor Adams filed a letter describing recent out-of-court statements by the Attorney General and DOJ staff, the Chief of Staff, that Adams says constitutes admissions of a party opponent under the federal rules of evidence. According to the letter, the Attorney General described the indictment in the case as incredibly weak, and the charges against the mayor were so weak she doubted prosecutors could seek a guilty verdict. Again, I have doubts that that's in fact true, but if it were in fact true, why not just dismiss completely? Right? Why not just dismiss completely? You know, the case is shit, which for the DOJ would be pretty typical. The DOJ, as a practice, is very small c conservative. They really don't like to bring charges unless they've got it 6 different ways. They don't like to lose. So they tend to be very, very cautious in bringing charges. They don't like to bring bullshit. And so the DOJ decline to prosecute literally happens all the time, which is one of the reasons that the DOJ is after you. You're having a bad day. So if the DOJ really thought it was this weak, the DOJ would typically just be like, well, we're not bringing the case, because the DOJ does it all the time. But they're not doing that. They're doing something else. And so that's a bit weird for the DOJ. That's not how they normally roll, which suggests maybe something else is afoot. Likewise, Mr. Merzel likewise stated in a post on social media, the case against Mayor Adams was just one in a long history of past DOJ actions that represent grave errors of judgment, and dismissing the prosecution was absolutely the right call. But why not with prejudice, though? Why not with prejudice, though? On February 26, 2025, Mayor Adams filed a motion seeking an order to dismiss the indictment with prejudice. In support of the motion, Mayor Adams argues the publication of the Sassoon letter caused him extreme prejudice because, among other things, it disclosed the Southern District prosecutors were seeking to re-indict him. Adams described the publication of the letter as constituting grave procedural misconduct, warranting dismissal with prejudice. In response, this court issued an order instructing DOJ to file any opposition to the motion, but no such opposition was filed. On February the 7th, DOJ, Mayor Adams, and the court-appointed amici, Mr. Clement, submitted their respective briefs. DOJ also submitted a motion seeking to seal various exhibits appended to its brief. DOJ represented the exhibits, which constitute communications involving former members of the U.S. Attorney, showed troubling conduct of the U.S. Attorney for the Southern District. On March the 11th of 2025, the court issued an order granting leave to file amici by various represent entities and individuals and denying motions submitted by pro ses. A scheduling order issued the same day adjourned oral argument as unnecessary, which is fine. You know, we don't necessarily need to do this in oral argument. We can do it in writing. On March 18th, the court issued an order granting in part and denying in part DOJ's motion to seal and directing DOJ to file exhibits to its brief on the public docket with only phone numbers and email addresses redacted. All right, so that's basically the procedural history of this thing. So now we're going to go get a little bit more into the legal standards relating to how we need to dismiss this. What is the law? Few subjects are less adapted to judicial review than exercised by the executive of discretion in deciding when and whether to institute criminal proceedings, or what precise charge shall be made, or whether to dismiss a charge once brought. Subject to constitutional constraints, and that's going to go a pretty long way here, such as prohibitions against invidious discrimination or vindictive prosecution, the decision to bring a prosecution generally rests entirely within the executive. But once the executive has involved the judiciary by obtaining an indictment or conviction, its discretion is tempered by the court's independent obligations. So the executive has lots and lots of power, but once you get the courts involved, well, you've got another branch of government involved. And so that's slightly, and I do think slightly is correct, slightly tempers your power, because we're not going to let you jerk the courts around, in addition to not letting you jerk the defendant around. By requiring leave of court for dismissal, the federal rules of criminal procedure deliberately altered common law rule under which a prosecutor could enter a nolle pros indiscretion without action. Rule 48's requirement of judicial leave, therefore known in state practice, gives the court a role following dismissal, but it is an extremely, extremely narrow role. As explained below, the rule has both procedural and substantive dimensions, both of which inform a court's decision to grant or deny, and if dismissal is granted, whether it should be with or without prejudice. The Supreme Court has addressed contours of Rule 48 on only one occasion, in a summary disposition in Rationale. There, in a footnote, the court explained that the words leave of court obviously vest some discretion in the court, but noted the precise scope of discretion had not been delineated. The court observed the principal object of leave of court requirement is apparently to protect the defendant against procedural harassment, such as charging, dismissing, and recharging when the government moves to dismiss an indictment over the defendant's objection, or even potentially with the defendant's objection, or without, because we don't want them jerking them around. But yeah, basically that's what we're trying to prevent. We're trying to prevent the government from just toying with the defendant. We're trying to prevent them from just bringing charges, dropping charges, bringing charges, never allowing the case to percolate long enough to have jeopardy attached, and just basically lawfare and just, being a jerk. So that's one of the things we're trying to prevent. But the court also noted some lower courts have held Rule 48 to permit a court to deny a government's motion to which the government has consented if it's prompted by considerations clearly contrary to proper interest. So even if the defendant says, I'm cool with it, the courts may not necessarily be. The court ultimately found unnecessary to decide whether a court has discretion under the circumstances, as it would not affect the outcome of that particular case. Lower courts before and after Rationale have taken care to acknowledge the narrow scope of discretion under Rule 48, stressing a court is not free to substitute its judgment for that of the prosecutor, who is entitled to presumption, and a strong presumption of that he's acting in good faith and in proper discharge of his duties. But that presumption is not conclusive upon the court, otherwise there'd be no purpose for Rule 48. Courts, including the Second Circuit, have therefore agreed that Rule 48 requires more of a court than serve as a rubber stamp for the prosecutor. Rule 48 asks the court to strike a delicate balance, deferring to the executive discretion where appropriate, but protecting against executive overreach in limited and, more to the point, very limited circumstances. Rule 48 is a very narrow valve in this situation. As the Fifth Circuit explained in its influential decision in Cohen, later quoted by the Fourth and Second Circuits, Rule 48 was not promulgated to shift absolute power from the executive judicial. Rather, it was intended as a power to check power. The executive remains an absolute judge of whether prosecution should be initiated in the first and it is the first and presumptively best judge of whether a pending prosecution should be terminated. The exercise of discretion with respect to termination of pending prosecution should not be judicially disturbed unless clearly contrary to manifest public interest. In this way, the essential functions of each branch is synchronized to achieve a balance that serves both practical and constitutional values. Rule 48A thus contemplates division of labor consistent with constitutional design, which enjoins upon its branches separate but interdependence, autonomy, but reciprocity. So once the executive gets the judicial branch involved, you now have two branches of government involved, and the judicial branch has some role here, mainly to prevent the defendant from being screwed over because of vindictive prosecution, serial prosecution, or other things that just basically toy with the defendant. Rule 48A requirements. Because the Second Circuit has had no opportunity to analyze the scope and discretion, courts in this district have relied heavily on the holdings of other circuits, which is what you do when what's the alternative, right? Right? If the Second Circuit hasn't provided an opinion, what else do you do? Well, you look to other circuits and see what seems like the best answer. That's, of course, what you do. The DC Circuit in Amberdown, synthesizing much of earlier case law on Rule 48, explained the rule contains both procedural and substantive components. As a matter of procedure, the court will not be content with mere conclusory statements by the prosecutor that dismissal is in the public interest, but will require a statement of reasons and an underlying factual basis. Again, we're not asking for much here, but we're asking for something. Thank you, Tony P., for the 10 gift memberships. They are, of course, extensively appreciated. You are the man. Ultimately, a court's inquiry is narrow. Only rarely will the judiciary overrule the executive branch exercise of discretion to eschew or discontinue prosecution. But critically, courts have noted that whether a defendant consents to dismissal is not dispositive. Again, we will protect you even from yourself. Rule 48 requires the government to set forth the basis of the motion. As Judge Wenfeld explained, the rule contemplates public exposure of the reasons for abandonment of the indictment, information, or complaint in order to prevent abuse of the uncontrolled power of dismissal previously enjoined. Accordingly, to gain the court's favorable discretion, it should be satisfied that the reasons advanced for dismissal are substantial and real. And again here, this is a pretty low bar. This is a pretty low bar because the court is going to try to give the power to prosecute to the executive. They're only going to not give that power if they think that they're toying with the defendant, if they think that this is, that they can just show only in really rare cases. See, for example, Flynn by comparison. Numerous courts of appeal have adopted similar reasoning. The reason for requiring the government to state its actual reasons for seeking dismissal is simple. Since the court must exercise sound judicial discretion in considering a request for dismissal, it must have sufficient factual information to support the recommendation. Put another way, the district court abuses its discretion if it does not articulate its reasons for granting or denying leave, and it cannot discharge its duties properly unless the underlying motion accurately states the government's reason for dismissal. Thus, although the court must presume good faith on the part of the prosecutor, it need not accept unsupported conclusory reasons. Yeah, the courts don't really do conclusory, right? You have to provide some reasons in your complaints. You have to provide some basis. You can't just say it's true. You have to make the argument. They don't really do conclusory. Consistent with procedural requirements of Rule 48A, courts have looked beyond the four corners of the motion to consider the entire record before the court, occasionally even conducting hearings to determine if dismissal is warranted. With respect to Rule 48 substantive requirements, courts have cited the protection of a defendant's right, a prosecutor's bad faith, and the public interest as relevant concerns. Courts have agreed the primary purpose of the rule is to protect defendants' rights. The Second Circuit, for example, has twice quoted Rinnendale's language. The principal object of the rule is apparently to protect the defendant against prosecutorial harassment, invalid prosecutions for bad reasons. But the lower courts have disagreed about the extent to which considerations of bad faith or public interest can also inform the decision about whether to grant leave under Rule 48. Courts addressing these factors have generally fallen into two camps. The Fourth, Fifth, and Eighth Circuits have treated prosecutorial bad faith and public interest as two sides of the same coin. A motion that is not motivated by bad faith is not clearly contrary to interest and must be granted. So basically, they're one and the same. Bad faith and public interest is the same thing by different words. The 10th Circuit and some district courts, including in this district, have spoken in public interest in terms that go beyond the motive of the prosecutor. So is public interest coextensive with the interests of bad faith? So that's a bit of a dispute. While the DOJ argues the Second Circuit is in the first camp, that public interest and good faith are identical, the circuit has not definitively ruled out either of these approaches. In Pimentel, the Second Circuit suggests in dictum that any authority it might have to deny a Rule 48 motion would be limited in cases which dismissal is clearly contrary to public interest. It may be dicta, but it's something, right? It was written by the Second Circuit in a way that wasn't binding in that case. So it's language that you could ignore because it wasn't binding, but it's something. And in the absence of, anything else, dictum might be helpful. In a subsequent case, the circuit noted that other courts have equated dismissal that is clearly contrary to public interest with one in which prosecutors appear to be motivated by bribery, animus towards the victim, or desire to attend a social event rather than trial. In other words, bad faith. But ultimately, the law has made clear it's ultimately declined to define the precise contours of a district's authority. So not quite sure what it is in the circuit, but we're going to give it our best. For his part, Mayor Adams argues the courts are not authorized to consider public interest in adjudicating Rule 48 motion because nothing in the language of the rule states that a district court is empowered to undertake a general inquiry into public interest. That argument goes too far. The text of the rule does not specify any factors to guide the court's decision whether to grant or deny leave, even the rights of the defendant, which all agree is relevant. So the rule doesn't help us because the rule doesn't tell us what to do. Right? It doesn't give us anything to work with. It doesn't even say the rights of the defendant in the rule. It doesn't give us any factors. So we've had to cobble it together from common law. Judicial decisions. Exciting. In any event, Mayor Adams' argument finds no support in case law and runs contrary to judicial interpretation of the rule, including Supreme Court's decision in Rationale, referencing the public interest as a factor courts have considered in ruling on Rule 48. Whatever the precise relevance of the public interest to a court inquiry under Rule 48, there's broad agreement that any judicial authority here is exceedingly narrow. Everyone agrees to that much. And the requirement of leave of the court is not licensed for freewheeling oversight of discretion. Also that. Few courts have denied a Rule 48A motion based on the court's independent assessment of the public interest. And indeed, there appears to be only one decision in this district doing so. Ultimately, the court does not, in its opinion, attempt to define the boundaries of permissible inquiry, which explained below is unnecessary to the court's decision given unique facts. So I'm not going to try to resolve the issue right now, and I don't need to as far as I'm concerned. We now come to the question of what remedies the court has at its disposal if the government's motion to dismiss is found wanting. Where a substantively deficient rule motion is brought by an individual prosecutor, a court's denial of the motion could presumably cause the government to make a new determination. For example, if a line prosecutor were motivated by bribery, animus, or desire to attend a social event, judicial exposure of such a substantively invalid reason might prompt reassignment of the matter to another attorney. So if the problem is with the one prosecutor, we can solve this by DQing the prosecutor. And we'll find somebody else. After reassessment of the case, the prosecution might continue, or if a fresh look reveals legitimate reasons for dismissal, it might not. By denying the motion, the court would play a fundamentally judicial role, reviewing reasons advanced for proposed dismissal and determining whether they're substantial. The executive, in turn, would decide based on the record exposed by court whether to continue the prosecution. Such a division of responsibility respects the role of each branch. But it's a different story when the executive has decided at the highest level of DOJ to abandon. Yeah, so now we're not just talking about the line prosecutor, we're talking about the CEO, right? And so how do we disqualify the entire DOJ? We can't do that. This doesn't make any sense. There's nowhere left to go. Although courts have discretion to deny dismissal altogether, they are nevertheless constitutionally powerless to compel the government to proceed. Yeah, I can't make the DOJ press the case. I can't force them to prosecute. If a Rule 48A motion is denied, the government can refuse to bring the case to trial within time limits of the Speedy Trial Act, in which the case has no court except to dismiss. So, the government can force it by just refusing to press on. As Judge Winfield explains, should a motion be denied, what next? The executive government is the head of the Department of Justice, a part of the executive branch. Even were leave of the court to dismiss denied, the Attorney General would still have the right to adhere to the department's view. The indictment cannot be supported upon true proof of the merits and accordingly decline to move the case to trial. Or alternatively, right, if somehow you could force them to trial, when you said, when you asked the government for its opening argument, the government could simply say, we rest our case. Right? The government just immediately rests. How can you stop them from resting? How can you force them to present evidence? It doesn't make sense. So the government's like, we rest. What are you going to do? Right? Doesn't make any sense. The court in that circumstance would be without power to issue a mandamus or order to compel prosecution, since such a direction would invade the separation of powers. And if the indictment continues to remain in status quo, each defendant would be in a position to move for dismissal under Rule 48B. When an unequivocal decision to dismiss has been made at the highest level, a judge could not possibly win a confrontation with the executive branch in order to refuse to prosecute. Again, if it were just some prosecutor who's refusing to prosecute, maybe I can DQ the prosecutor. If it's the entire DOJ, there's nothing really here I can do. The precise scenario played out in Rationale, the one case in the district where court denied a motion on public interest grounds. There, the government, after denial of its motion, simply chose not to further prosecute. Around 1 year later, the defendant moved to dismiss the indictment on essentially speedy trial grounds. The court reluctantly granted defendant's motion to dismiss, saying it did so despite its continuing conviction that the interest of justice had been ill-served. So yeah, it's like, okay, in that exact case, that's what happened. So the government moved to dismiss, the court said no, and then they just decided not to do anything. And then they're like, okay, speedy trial dismissal. So you can't, what are you going to do? You can't stop us. Can't stop, won't stop. The possibility of such an impasse is product of design. In our system of separation of powers, the role of judiciary is to say what the law is, not to take care of the law be executed. More specifically, courts are particularly ill-suited to weigh factors typically relevant in determining whether to pursue prosecution, such as strength of the case, general deterrence, government enforcement priorities, and case relationship to the government's overall enforcement plan. Judicial role is to preside over the case, not to decide whether the case should continue. This is not simply a matter of comparative institutional competence. It also reflects structural principles secured by separation of powers. This is why even if a federal judge could properly deny a motion to dismiss a criminal charge, it would not follow that it could appoint a prosecutor. Although various amici argue a court can appoint special prosecutor upon denial of Rule 48A motion, they generally rely on authority in contempt of court context, which presents markedly different considerations. The Supreme Court has explained that courts possess inherent authority to initiate contempt proceedings for disobeyment to their orders, authority which necessarily encompasses the ability to appoint a private attorney to prosecute contempt. Amici cite no authority, for example, of a district court appointing a private prosecutor in a criminal case outside contempt. So, if the executive branch, right, if let's say I wanted to hold the prosecution in contempt, right, and the prosecution's like, neener, we're not going to prosecute ourselves, you dumb judge, or you dumb judge. Well, the Supreme Court's like, no. You have inherent authority as the court, and the government's jerking you around. You can appoint a prosecutor for that reason, because of your inherent authority. But that limited exception, of course, does not go beyond the domain of that turf. Thus, while a court could, in theory, deny a Rule 48A motion even were made at the direction of DOJ leadership, such a denial would almost certainly be an exercise in futility. The court cannot appoint its own prosecutor, absent a sudden change of heart at DOJ, which doesn't seem like it's going to happen. Such a denial would only produce a staring contest followed by inevitable dismissal on speedy trial grounds. All right, so notwithstanding the specific limitations of court authority to deny Rule 48, motion to dismiss altogether, a court retains discretion to determine whether dismissal should be with or without prejudice. Typically, dismissal under Rule 48 is without prejudice to the government's right to reindict unless contrary expressly stated. But if appropriate, in light of the purposes of Rule 48, a court can grant the motion on the condition that dismissal be with prejudice, ensuring that charges once dropped cannot be resurrected. The First, Seventh, and Tenth Circuits have either affirmed such dismissals or otherwise endorsed the practice. Numerous district courts have dismissed prosecutions with prejudice, even where the government seeks dismissal without it, to protect defendants from unwarranted or inappropriate threats of reindictment. Facts. The Second Circuit has thus far declined to rule out discretionary dismissals with prejudice in similar contexts. But the circuit has not specifically addressed under what circumstances, if any, a court may dismiss an indictment with prejudice, notwithstanding the government's request to dismiss without prejudice. So this circuit has not answered the question. So once again, I have to go to law beyond the circuit. In exercising discretion to dismiss with prejudice under Rule 48A, where it's routinely applied to consider dismissal with prejudice, Courts take into account the purpose of dismissal, the presence or absence of good faith, and objective effect of dismissal without prejudice. Courts in this district have had less occasion to consider the question, but have tended to look to whether there's a risk of procedural harassment from recharging the offender or whether there's evidence of bad faith on the part of the prosecution. Thus, while bad faith is relevant consideration, most courts do not require a finding of bad faith to grant dismissal with prejudice. Converting a dismissal without prejudice to one with prejudice does not raise the same separation of powers as outright denial. When a court grants the government's motion to dismiss, it respects executive branch's primacy in matters of discretion. The determination of whether dismissal should be with or without prejudice does not entail the kind of incursion in the executive branch that an order to pursue unwarranted prosecution would. It's like, I'm not forcing you to prosecute. I'm just saying you can't jerk the defendant around, right? The defendant has rights. And also, the court doesn't want to be jerked around for that matter either. The court doesn't appreciate it. All right, discussion. DOJ seeks dismissal without prejudice of the charges in this case. The effect of such a dismissal would not be akin to that of a presidential pardon, which once accepted releases the wrongdoer from punishment and restores the offender's civil rights. Instead, DOJ seeks to terminate the prosecution at this time, but has confirmed that if its motion were granted, Mayor Adams could be reindicted on the same charges with no clear limits on grounds or timeline. And the government is not committed to halting any additional investigative steps with respect to Mayor Adams. Instead, the DOJ has represented that in its discretion, may or may not at some point revisit whether the charges are appropriate, even though the DOJ thinks the charges are so weak they can't withstand scrutiny, which seems like a slightly odd choice. The prospect of reindictment therefore hangs like a proverbial sword of Damocles. I'm a sucker for the phrase sword of Damocles. I like it. So +1 law point just for saying sword of Damocles, because it pleases me. The court begins its discussion with the government's motion itself and concludes the reasons articulated when assessed in light of the purposes of Rule 48, counsel in favor of dismissal with prejudice there and without it. The court then turns to criticism of DOJ's reasons for dismissal raised by various amici and concludes that while they have merit, they ultimately point in favor of the same result, not denial of the motion, but dismissal with prejudice. The court has considered the party's submission in light of the purposes of Rule 48 and ultimately conclude the form of relief DOJ seeks is inappropriate. In reaching this determination, the court focuses its analysis on submission of the parties, written and verbal, and does not consider additional factual materials submitted by amici. That is, leaving aside factual submissions by amici, the court concludes that under proper application, dismissal should only be granted if it's with prejudice. Courts have generally agreed the primary purpose of Rule 48 is protection of defendants' right, including the right to be free from prosecutorial harassment. The court's discretion to condition its granting of Rule 48 motion on dismissal being with prejudice is critical to fulfilling that purpose. A court can determine whether the potential for harassment renders dismissal with prejudice in the public interest by looking at the purpose of the dismissal and the effect on the defendant. Here, the motion advances two grounds: appearance of impropriety and risks of interference with the 2025 election in New York City, and interference with defendants' ability to govern New York City, which poses unacceptable threats to public safety, national security, and related federal immigration initiatives. Both rationales have taken at face value counsel in favor of dismissal with prejudice. As articulated in Rule 48, the appearance of impropriety rationale rests in part on allegedly improper statements by former U.S. Attorney Williams on his personal website in an op-ed. To the extent the DOJ believes the purported appearance of impropriety here is so severe it warrants dismissal, then such concerns would be conclusively resolved only by dismissing it permanently, that is, with prejudice. kind of, sort of, right? If these statements are so prejudicial, right? If these statements are so prejudicial, how could the prejudice be cured? You know? Fair point. If, as DOJ asserts, this prosecution has been tainted with appearances of impropriety, it's unclear why the government should be permitted to reinstate this case in the future. To the extent DOJ might argue that any whiff of impropriety could fade over time, such that it could bring a new and untainted prosecution bring on charges of the indictment, that would entail precisely the kind of prosecutorial harassment that Rule 48 is meant to guard against. The question is not whether the government was acting in bad faith, but rather whether actions the government objected to amount to harassment. And it would be objectively amounting to harassment to allow the prosecutor to dismiss charges, but nevertheless keep them in abeyance for an indefinite period of time in the hope or expectation that something will turn up to remove the complications. This is also incidentally why you don't want to bring charges necessarily before you're ready. Because if you think that the case is weak, maybe you need to bring charges later after more investigation or something. So, there's that. Here, although DOJ disclaims any concrete plan to reassess the case, its proposal, which will allow it to hold out the possibility of re-indictment in the hopes of the purported taint of impropriety might eventually fade, thereby puts the government in a more favorable position to try a second time, which amounts to harassment. DOJ's second rationale for dismissal, that prosecution by interfering with mayor's ability to govern threatens various federal priorities, including federal immigration and policies, similarly points in favor of dismissal. Dismissal without prejudice based on this rationale inevitably creates the appearance the mayor may be beholden to the federal government, which again conflates his personal role with his professional role. It conflates the person with the office, which holds the prospect of re-indictment over him should he ever fail to adequately effectuate the goal. Thus, although dismissal without prejudice always comes with some inchoate risk of re-indictment, this status as a public official raises special concerns because it conflates the personal with the professional. As the court's appointed amici explains, concerns with appearance that the executive branch was either targeting political opponents or seeking to exert undue influence over other office holders prompted the creation of the Public Integrity Unit. Moreover, perhaps as a consequence of distinct problem posed by even the appearance the executive branch was leveraging over an elected official via re-indictment, deferred prosecution agreements in the context of prosecution of public officials are exceedingly rare. To be clear, the question is not whether the government was acting in bad faith. It's the effect dismissal without prejudice has on the defendant. And here the effect of dismissal without prejudice is unavoidable. This prospect of re-indictment could create the appearance, if not the reality, the actions of the public official are being driven by concerns about staying in the good graces of the federal executive rather than best interests of his constituents. The lack of clarity around any timeline or criteria for reassessment only heightens this concern, leaving the mayor and the broader public in the dark as to what conditions might renew trigger of the indictment. Under these circumstances, if the government's motion were granted, the mayor would be prejudiced by having to wait in a state of uncertainty and under public obligatory for an indefinite period of time. While that is in some sense true for any indictment where indictment is dismissed without prejudice, the unique combination of factors here, including dismissal status as an elected official and DOJ's asserted rationale, raises unique concerns. In view of this court, such a process would not be fair to the defendant. The court has an obligation to protect him from uncertainty entails and from what objectively would be harassment. By contrast, dismissal with prejudice would put any concerns to rest. For their part, the parties are often no good reason why dismissal should be without prejudice. To be sure, Mayor Adams consents to it. As Rationale notes, concerns about prosecutorial harassment typically arrive where the government moves to dismiss over a defendant's objection. But even where defendant consents to dismissal, courts have an independent obligation to ensure defendant's rights are protected. We do have the obligation to potentially protect you from yourselves and also protect the courts from the bullshit. Here, for reasons stated above, the court determines that in light of DOJ's asserted rationale, dismissal with prejudice is most appropriate result and best aligns with the purposes of the rule, notwithstanding consent. Moreover, Mayor Adams' consent to DOJ motion has moved separately for dismissal with prejudice on other grounds. And throughout his brief, he argues the court has power to grant dismissal with prejudice. Mayor Adams' consent to dismissal without prejudice appears to be equivocal at best. Even if the DOJ's motion were granted and indictment dismissed without prejudice, he would still have the requested for additional relief pending before the court. Nor has DOJ meaningfully opposed such a resolution. In response to the court's discretion to address under what circumstances, if leave is granted, dismissal should be with or without prejudice, DOJ offers no reason for dismissal without prejudice other than it is default. Yeah, that's not necessarily good enough. The court has been offered no reason to think the rationales offered by the motion or the purposes of the rule would be better served by dismissal without prejudice. The parties have been offered essentially no basis to conclude that dismissal, if granted, should be without prejudice. And because DOJ has not opposed Mayor Adams' separate motion to dismiss, he has waived the opportunity for relief. In sum, the court concludes that if dismissal is to be granted, dismissal with prejudice, it best conforts to this understanding. In reaching a conclusion, the court need not find any bad faith, rather DOJ's own proffered justification weigh in favor of that. Having determined that the dismissal of this case should be only with prejudice, the court now turns to argument that the dismissal should be denied altogether. Several amici argue, notwithstanding the presumption of good faith and court's narrow role, in a cursory review of the record here compels the conclusion that DOJ's rationales are inadequate and the motion should be denied. The court is largely persuaded by the merits of various criticisms of DOJ rationales. But for reasons explained below, the court concludes that they do not counsel in favor of denial of the motion under circumstances presented here. Instead, they support the same conclusion the court has reached in taking the motion at face value, that dismissal with prejudice is the most appropriate result. One preliminary matter: it's unclear precisely what materials the court may consider in resolving the Rule 48 motion, particularly in light of presumption of good faith. The parties themselves here are not consistent on the point. At times, they appear to suggest the court may not look beyond the four corners of the motion. At other times, they point to their own additional submissions on the docket, including their prior filings, letters submitted in connection with the motion, and extending to their briefs. During the conference, the court asked Mayor Adams a number of limited questions under oath to ensure his consent was knowing and voluntary. The parties did not object to the questioning, in fact, rely on Mayor Adams' response in their respective briefs. For their part, Mayor's counsel have acknowledged the court may consider amici briefs, many of which include various documents, and they have on several occasions even offered to supplement the record with their own sworn testimony. It's inconsistent for the parties to ask this court to consider materials they've submitted that are extraneous to the motion while ignoring other material in the docket, especially memorandums and letters between U.S. Attorney and DOJ, the authenticity of which has not been disputed. And particularly, DOJ authenticated the decisional memo directing dismissal of the case. It's difficult to see how the court can discharge its duty to ensure the reasons advanced for proper dismissal are substantial and real. And the parties ultimately cite no authority for the notion the court may only look within the four corners of the motion. Rather, there are numerous cases indicating the court have looked to the entire record of the case and not just motion papers in adjudicating the motion. And courts have sometimes had evidentiary reasons to assess the validity of the motion. All this is consistent with procedural requirements. It's therefore clear the court need not confine its review under Rule 48A to the motion, but the court concludes in this case it need not determine the outer boundaries. That is because the court, even if it were to consider various factual materials that have been put before amici, arrives at the same conclusion. Dismissal with prejudice is appropriate. According for the purposes below, it considers such materials. And I think I'm just going to skip the rest of this because they get into like whether or not, other things, but we kind of have covered the ground, and I don't think there's any reason to read the remaining pages because I think that sort of summarizes the thing. So I think that's going to bring us to the end of the stream, and that seems pretty reasonable to my mind. It's very difficult to take the position simultaneously. These charges are super duper weak and stretches the law in fact, but we should also hold it open indefinitely. And the other factors in play with respect to timing suggest quid pro quo, and also there are other factors in play. So I'll take a quick look at chat to see if there are any questions before I wrap up. So if you have any questions, I'll take a moment to answer those before I end the stream. Anyone have a question? Okay. Well, seeing no questions, then I'm going to go ahead and end the stream. I've had fun, and I hope you've had fun too. It's been an interesting ride, and I hope that you'll remember to hit that like button. Until next time, I've been Uncivil Law, and until later, my friends, have a good one. Cheers, and goodbye.